The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the termination of parental rights in Illinois. We've got an article and video at learn-about-law.com talking in detail about voluntary termination of parental rights, so basically relinquishing your rights in connection with an adoption case. Now we're going to talk about involuntary termination of parental rights. There's three grounds that you can use to terminate someone's parental rights. One is that they're an unfit parent. Another is that they're not actually the biological father of the child. A third ground is that the child was fathered as a result of criminal sexual abuse or assault. So if you want to learn more about the paternity aspect and proving that someone is or is not the biological father of the child, check out our video and article on paternity. We're not going to talk about the criminal sexual abuse and assault piece here. What we're going to talk about is proving someone is an unfit parent. So when you're proving someone is an unfit parent, this can occur in two contexts. One is an adoption case. The other is a juvenile case brought by the state. So in an adoption case, the usual context is where there's a step parent that is willing to adopt the child, and the biological parent is not willing to cede their parental rights. You can't have the step parent adopt without the other biological parent having their rights terminated. If they're not willing to voluntarily terminate the parental rights, then the only way to have the adoption take place is to show that the biological parent is an unfit parent. And so here's the basis for doing that. There's several grounds that you can list to show that the biological parent is unfit. One is that they abandoned the child, meaning showing no interest for a continued period of time in the child. That includes failing to maintain reasonable interest, concern, or responsibility with respect to the child's welfare. Another ground for unfitness is continuous or repeated substantial neglect of the child that's kind of similar to abandonment. Another is extreme or repeated cruelty to the child. Another is physical abuse. Another ground is failure to protect the child from conditions in the child's environment that are injurious to the child's welfare. Conviction of certain depraved crimes. Depraved is a term of art. This is crimes like murder or sexual assault. Habitual drunkenness or drug use. Continuous or repeated failure by the parent to provide the child with adequate food, clothing, or shelter, despite being physically and financially able to do so. Or a mental impairment or illness that prevents the parent from discharging parental responsibilities. Any other grounds that show that it's in the best interest of the child to terminate parental responsibility can also be used to show unfitness. But those are the standard ones that are listed in statute, the adoption statute, as a basis for being an unfit parent. So when you're proving someone is an unfit parent, you have to do so by clear and convincing evidence, which is a higher standard of proof than preponderance of the evidence. Courts don't really like to take away parental rights. And just because you have a step-parent that's willing to adopt the child doesn't mean that all of the things being equal, parental rights are going to be terminated. The biological parent actually has to mess up pretty badly and has to have one of these grounds come into play and be provable by a high standard of evidence. Now, the parent against whom the unfitness claim is being made can make several counterarguments. And this is usually, the ones we're going to talk about are usually in the context of neglect or abandonment. One counterargument is proving that he or she had attempted to create a relationship with the child, or had been paying child support, or had been attempting to visit or correspond with the child, but that the other parent was interfering with these attempts. So any attempt by the biological parent who's trying to terminate the other parent's parental rights, any attempt by them to interfere with that person being a parent is going to be a really good counterargument against them not being involved in the child's life. So we've talked about what goes into unfitness, but I mentioned earlier that this is usually only used in adoption cases or juvenile cases. So let's talk about that a little bit. Courts don't like to deem someone an unfit parent and take away their parental rights unless there's somebody else willing to step into their shoes. So it's not a situation where in an adoption, in a vacuum, someone who doesn't like the way the other parent is acting or behaving can just file a petition to take away their parental rights and have all of the parental rights left with the remaining parent. The court wants to see another parent, usually a step-parent, willing to step in and take that burden. And here's why. The parental rights can be divided into financial obligations to support the child and actual rights to see, visit, parent the child. If someone is a bad seed and doing all these things that are neglecting, abandoning the child, doing things that can negatively impact the child's best interest, then the proper thing to do is for the court to take away any right to access the child while leaving the financial responsibility in place to pay child support. And the reason the court wants to do this is because if you take away one of the parents that's responsible for the child, it's more likely that the other parent is going to depend on the state to support the child. So the court wants to keep two parents in the scenario, and usually that's why this is done in an adoption proceeding. So if you have someone else willing to adopt, then you can involuntarily terminate parental rights by showing unfitness to be a parent and that you've got someone else willing to adopt. However, the state can file a juvenile case and terminate parental rights even if there's not someone willing to step up and adopt, and either that the state will be in charge if there's no other parent, and the state will be in charge of finding an adoptive parent down the road or foster parents, or if there is another parent involved, then all of the parental rights and responsibilities and obligations will fall back on the other parent. But you can't, as a civil person, initiate a juvenile case. That's not something that, it's not a civil case where you can just file a petition. The state has to initiate that case, and it's usually in the case of abuse that they'll initiate that sort of case. If you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube channel. If you found this helpful and would like to be informed of our daily article and video topics, subscribe to us on YouTube, iTunes, and SoundCloud, and that helps us too. If you need some help, please feel free to call for a free consultation at 630-324-6666. That's 630-324-6666. We have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.